My name is Robert Vincent Makaramba. I'm a retired judge of the High Court of Tanzania. When we talk about protection of journalists, we are basically talking about prosecution and the investigation and, the protection. We have two basic problems. The first one is what we call impunity, and the second one, bad laws. If I start with bad laws, in most jurisdictions in Africa, you have laws which actually affect journalists. Well, I'll give you an example. What we call criminal defamation. In Tanzania, we have it. And according to international standards, criminal defamation is not a very good idea. You need a lot of awareness so that people might realize that these are fundamental rights which need to be protected. Now, in terms of impunity, people, they don't feel like they have a duty to protect those rights. The safety of journalists, we still don't take it seriously. We think it is the problem of the journalists. And as I said, that is what creates impunity. First of all, I must really thank UNESCO for coming up with this program. We did some training of trainers on freedom of expression and freedom of the press and journalist safety. The other thing was the new topics, especially on the digital freedom, which is a new topic combined with the artificial intelligence. And if I may tell you, the Judiciary of Tanzania is coming up with an artificial intelligence program. We use Kiswahili as a local language in the judgments. Now we've come up with a program which can actually do automatic translation of those judgments so that it can be understood by people who don't speak Kiswahili. So artificial intelligence is here with us, and I think that's the future of justice. So we need some more training to get prepared for what is coming. We have a problem on how to internalize the international standards on freedom of expression, because these are international standards, and we come from a common law country. In a common law country, international treaties are not directly applicable in our country. It's different from Kenya, where the Constitution recognizes treaties as part of the national law. But here, it's purely common law on the what we call the dualist approach. Now, that is a problem when it comes now to applying those standards in a court of law. Most of the judges are trained under the common law standards. They will be asking about where is the law which will apply and affect your rights. I actually had recommended that we have a compendium of national case law, which can help the judges. Of course, it will combine also cases from other tribunals outside the continent and even international, especially the European Court. So those are the kind of things to make the judges realize that those international standards are not hanging in a vacuum. You can apply them in resolving issues at the local level. And that is an area where we need much more kind of effort to be done.